Where is Mr. Prasad? Still there? No? I don't know. Yes, you were supposed to make submission. Hmm? Yes.
Accused rightly convicted in the section 326 section 1812 to 2002, informant Lucas Federer, he has lost and acquired properties, stating inter alia that on the same day, that is 1912 2002, at about 10:30 a.m., one Sri Borsing Angshu, the president had cut and injured conservative Navin Sikhi. Without any reason, the accused person also cut the only child, the little child of the victim, that is Kamini Hamsaki, whom she had taken to the place of visit. That is the house of the accused person. And moreover, Darshan, he has also cut his wife. The accused petitioner also cut his wife, sit down, and she has also sustained injuries. And thereafter, he has also stated that the accused has already surrendered into the police station after the release of the inspection. So in that nutshell, this is a prosecution story, Worship, in order to prove the guilt of the accused person to the release crime, prosecution is examined as well as 10 prosecution witnesses caution, including the victim, IO, medical officer, and the executive assistant. The accused was also recorded, is examined under section 313 of the sentence. And defense also introduced evidence. Examining one witness that is state of the father of the deceased person. And defense has taken the plea of total denial. So in the earlier occasion, the worship is repeatedly discussed the depositions of the prosecution witnesses portion, including the deposition of the groups one portion. And it is clear from the evidence on record and the evidence of the examination of the witnesses portion that the entire prosecution case is based on documentary evidence as well as sons. It may be considered in sons witness. So Lordship has rightly pointed out a query, if supposing for a moment, if the star witness that is PW3, if he happens to be a chance witness, so how far his statement can be relied upon? What is the admissibility value of the son's witness? So that query Lordship has earlier raised in your presentation. My contention is this question. The expert is held in its scattered consciousness. And only because of the reason that which had such witness evidence cannot be thrown out. Only because he's a suspect. So his statement can be, his deposition can, evidence can be relied upon. If it is found to be truthful, and if it is corroborated by other evidences, evidence. And my contention, my submission, I'd like to rely upon PW3, who happens to be the star witness. We are also considered him as a son's witness. Question. To that regard, may I submit and may I read the entire depositions from
Not required.
not record only the deposition of PW3.
Hmm.
So the Russian will get the deposition of PW3 at base 10. So
Hmm.
it's mere read motion. I know the informant, the accused, the deceased, and the injured person. The incident took place about 17 years back. On the day of the incident, I went for a stroll in Silver Street. When I passed by the front of the accused person's house, I saw him hacking injured in his unsafe son with a dog in his courtyard. Thereafter, the accused chased to hack another boy of the injured. Just then, finding the injured person, the accused hacked R2. I took the injured person's other son, who had run away, to the injured person's house and hid him there. The injured person's one son died in the courtyard of the accused cell. After moving forward a little distance in the accused person's courtyard, the injured person fell to the ground unconscious. I then took the injured person to the hospital. I saw the accused going towards a police station with the dog in hand. The incident took place around 10:30 a.m. The house of the injured nonny and the accused person also were adjacent to each other. The injured person was treated in hospital and demoted for about 20 days. The police arrived at the place of occurrence, took the dead body of Raki's son to the police station. The dead body was taken to Bifu Government Hospital for postmortem examination. When the dead body was taken to Bifu Hospital, I also accompanied him to the hospital. I was present when police had arrest on the dead body and put my signature as witness. Exhibit 2 was the inquest report and exhibit 2 was my
Now,
signature.
in his chief, this man has said,
Yes.
I saw him hacking injured Kamini Hansepi's son, which is now in his courtyard. This we could understand that it was the deceased. Then he said, thereafter the accused says to hack another boy.
Perhaps that is not relevant. Also, on the material point that the accused person.
Because another boy nobody has mentioned.
Yes, nobody knows. That is perhaps not relevant. I'm coming to the cross-examination. The distance of the place of occurrence from my house is about 7 kilometers. The injured person's husband is my elder brother in relation. On the day of the incident, I went to pay a visit. Injured
1 minute, this injured is
PW5.
Kamini. Kamini is wife of Sar Singh Karam, right? Sar Singh Karam is DW1.
Yes.
Now, this accused, who is related to Sar Singh Karam?
He's a
Accused or accused wife?
accused husband.
No.
One version.
My wife,
Who's accused wife? Her name is
Allah,
Mala
Allah,
Ing Tipi. Mala Ing Tipi and Sar Singh Karam, Kamini Hansepi and Mala are sisters. But they are sisters in relation.
And PW3 is the cousin brother of
Sar Singh.
Cersei.
Hmm.
The injured person's husband is my elder brother in relation. That means Kamini's husband is his elder brother in relation with his cousin. On the day of the incident, I went to pay a visit to injured Kamini's home. Nobody called me to come there. When I arrived at the place of occurrence, the accused person, his wife, and the injured person who was on a visit there were present there. I do not know if there was a dispute between the accused, deceased, and the injured person. When the accused person hacked the deceased and the wounded, Kamini's father-in-law, Kota Karen, was there. At that time, injured person's father-in-law was consuming liquor at his house. His
Father-in-law. Okay. Mhm.
He is my uncle in relation. Kamini's father-in-law is his uncle. in
But
Procecution.
uncle in, okay, uncle, okay, yes.
Yes. I do not know why the accused had hacked him to receive the nature.
This Pota was examined, not examined.
Not ex-
He expired or what?
just,
Search sheet, where is the search sheet otherwise?
So status. Basically. 107,
107.
Exodus 6.
He was not a listed.
Yes.
Yes, that's fine. Yes.
So,
He was one person who was present
yes,
at the PO,
yes, but
but he was not examined as a witness.
not in the view because he was at his house,
Uh,
where the house of Kamini's house, he was present, which is adjacent. to the
Kamin
accused
is,
house.
okay,
Yes.
okay.
Not sure. I do not know why the accused has hacked him. I do not know whether the accused is under the influence of alcohol at the time of the incident or not. Does not affect that I did not witness this incident. Yeah, sure. You
Now, few witnesses said PW4, Mala. She said differently, has not supported the prosecution case fully, except she saying that I saw Kamini's son lying in the courtyard. Hacked with a dao. I saw wounds on his back. At that time, no one present in my house. She has deviated.
seems to have hated, but
She was not declared hostile to an extent.
but her statement is seems to be not correct because it seems to save her own skin. Seems to save
So
her.
if she partly corroborates prosecution case and does not corroborate the other part of the prosecution case, how her testimony is to be appreciated?
Worship. On the
Case
material,
there.
on the material point, that the dead body was found on the courtyard of the accused person. And lordship, her statement cannot be taken fully relied on because PW6, who happens to be the doctor. And lordship will get it in page 16. So he has examined Kamini and lordship, Panda lordship, on that day. She has also sustained injuries.
Okay, next part, her testimony regarding illness of the accused, plus supported by PW4 also to an extent.
Lordship.
PW, that is the injured. I heard that. Page 50.
Lordship. PW.
PW4,
Lordship.
injured witness.
Yes,
Page 15,
page 15.
PW5.
PW 5 is start. Yes, Lordship.
I heard that the accused had become insane.
Yes.
I do not know if the accused had committed this incident as he had got insane.
I do
The
not know
accused
if that-
committed this incident as he had gone insane.
But
He
that
had
is-
not hacked us intentionally.
Yes,
What do you say about this?
that is not yet proved that his insanity count cannot be taken. That is not, that no suspicion was put by the defense that he is a insane person.
What is the law?
Insanity
This is a general
insanity
exception.
is a law. Insanity is not
General
a
exception.
Yes,
It is perhaps under section 84 IPC. The injured witness whose testimony is to be treated at a higher pedestal.
so,
Defense had elicited out of her that he had not hacked us intentionally. This has been elicited from the injured witness whose testimony is to be treated at a higher pedestal than a witness simpliciter And further said, accused committed this incident as he had gone insane.
Yes.
Wife also says something, something,
That's
PW 4.
four.
During that period, he had been in a restless state, wanting to flee here and there, did not want to stay at home. He got scared when he saw someone else. His fell.
That was taken by the defense.
So, by the trend of cross-examination, it appears.
But the,
From the,
but the-
because to bring the general exception or special exception, the defense or accused need not enter into witness box. He can take support from the evidence on record. It is a case of preponderance of probabilities. So, PW 4, yes, we could gather that it cannot be ruled out that to the PW 4, the being the wife of the DGs, deviated or tried to salvage the situation and to extricate her husband out of the clutches of conviction. It cannot be ruled out. But so far as the injured witness is concerned, she said something. How to treat this?
her statement cannot be taken into relied upon because she may read her statement again.
Cross part. Cross part, page 15.
When I got the news while I was going to pet control, but did not find anyone in the house.
No, page 15, page 15.
Please, Mala,
We can say that she tried to save her husband. Mala, Mala,
I'm
but
not
so,
relying on
all right, but Kamini,
Kamini's
page 15.
Please 15.
Hmm.
Is the mother of the deceased.
And the injured also.
Rely on her statement. Because of the. May I read her statement again? I know
First part we have read, page 15.
Page 15. I do not know whether the accused was mad at the time of the accident. We had no dispute with the accused. We had a cordial relationship. That is why I went to inquire about his health. I heard that the accused has become sick.
And that is why she had gone there
Yes,
to inquire about it.
yes. I do not know if the accused had committed this incident as he had gone sick. That is also relevant, lordships. He did not know.
Then,
Then at that time, no one was present there.
Then-
The accused committed this incident as he had gone insane. He had not helped us intentionally. So she has given it to contradictory statements. I do not know if the accused has committed this incident as he had gone insane. Thereafter again, she said, at that time, no one was present there. The accused
Okay.
committed this incident as he had gone insane. Contradictory statements. Yes. So basically relied on prosecution witnesses with 3 years. On material point that the accused
how PW3 can be everywhere? PW3 was at the place of incident at the time of commission of the crime. Then PW3 also was at the school of the husband of the injured, father of the deceased.
also
Thereafter, he was also at the hospital treating the injured. Then he was also at the police station. He was also at the time of post-mortem examination.
lots. being a
He
subs-
seems to be omnipresent everywhere.
being a subwitness, it's very much
He cannot be a such witness. Such witness, after seeing the incident, he goes to his home. He cannot be treated, though we thought that he is a such witness, but having his involvement in the post-occurrence events,
yes. That is also very.
he was very much involved.
Yes.
So, being a relation, yes, his presence at the time of occurrence was by chance. But he is not a stranger.
But
He is not a stranger either to the deceased or to the accused, right? So his presence was by chance,
yes,
but he is not a stranger.
yes,
And people occasionally visits relatives' house. In villages, I have seen. Without anything, and in earlier times, it was 20 years back.
yes.
Nowadays, you, Mr. Prasad, if somebody I want to go, please inform me beforehand.
Lordship,
If somebody says
lordship,
5 days today, that I'll come
lordship.
to your house during the weekend, then your immediate response would be, please give me a call before you come. But 20 years back, or what was the two, that was not the situation. And plus in villages it happens. So he is not a such witness totally.
Is an eyewitness as well as some witness.
He cannot be a chance witness. Chance witness by chance, but
Yes.
all his involvement in every stage subsequent to the death
Yes.
does not make him a totally such witness.
Conduct of the accused person subsequent to the occurrence.
Contrary to Mr. Prasad's submission that he is a such witness. No, he is a relation, he is not a stranger. He was not a stranger.
Or he used to used to stay
Attend
from
different
the house of
places.
the accused person 7 kilometers away. On that very day, Lordship, he went to pay a visit to the house of the deceased person's uncle's house, and by chance, since the occurrence take place in the courtyard of the
Because you see, say, inquest,
Lordship,
page 96. At what time? That was done on which date? Page 96.
yes, Lordship.
That was done on
That was done on Lordship,
19/2.
1912,
19/2 is the incident,
1912.
1912.
Yes,
Date of incident.
yes, Lordship.
So inquest means at the police station perhaps.
Lordship,
He was there, page 97.
yes,
Then you see page 99. Seizure, police station.
Lordship.
He was there.
He was in.
Then you see page 101
Lordship,
at 1 p.m.
yes,
1 p.m. Somebody said he took the injured there.
Lordship,
Then if you see page 102, postmortem,
yes,
102, he was there. That is on the next day.
yes, next week.
Then you see DW,
Yes.
Wow.
He was informed.
he had gone there to his school. He had done so many activities on one particular day.
Lordship.
His signatures are there, his signatures are there, cannot be disbelieved. He seems to be a very active person.
Otherwise, conduct of the source witness, Lordship, subsequent to the occurrence, it can be taken into consideration, Lordship, because he has, Lordship, very Specifically, Lordship, he has answered. the point.
We are testing possibility and impossibility.
Yes,
To be of BW1 to be present at the time of occurrence, going to the school of DW1
yes,
to inform him.
yes,
Thereafter, taking the body or injured to the hospital.
yes,
Thereafter, going to the police station,
yes,
right?
yes.
Witnessing the seizure of now there everywhere. Let us see the doctor
Doctor,
who treated the injured.
that lost it at page 16, GW6.
EW6. Okay, it was, no, his name was not there.
19/12/2002, I was addressed with
One.
the date of at 1 p.m. My examination of the community recipient found the following: hip cut injury over right side of knee or muscular structure. Recently is in pool of blood, pool of injury by sharp cutting object. It should be was so. She has also examined Mrs. Hala NTP and found the
Yes,
correct
yes.
exam. And that is nowhere mentioned that this person is missing.
The meeting was surrender. And what about how the act of surrender is to be appreciated?
PW3, he has stated that I saw the accused going towards the police station with the dove in hand, and his statement is corroborated by the evidence of.
In the evidence, like how this is, how an act of surrender is to be, is it an incriminating circumstance or,
PW1.
right? He had appeared before the police station with a dove in hand.
Yes,
Now, how this event
yes.
is to be appreciated, whether it is an incriminating circumstance as per the evidence,
Material exhibit. The doubt is been,
dove was not sent for,
that is not set for any. This seized. In front of the illegal and witnesses.
no, events are clear. Now I am asking you about the appreciation part. How it is to be appreciated. Corroboration, all these are okay. I am asking you the question that how this event is to be appreciated as per the Evidence Act.
Okay.
That otherwise events everybody can read. Consistencies, inconsistencies, corroboration, right?
Yes,
Exaggeration, embellishment, we can find out. But the treatment under the Evidence Act, how it is to be. That is a good question always. Everybody knows what have emerged from evidence on record. After he said, somebody said, now BW3, who is your star witness? He said, I saw the accused going towards the police station with a dove in hand. Under the Evidence Act, under which provision this event is to be treated and appreciated? This is on these points, we need the assistance of the counsel of the party. Have you understood?
yes.
BW3 saying that I saw him going towards the police station with a dove in hand. That is one. Somebody else saying that he appeared at the police station with a dove in hand. Statement of police personnel is always to be seen with a pinch of salt. But others at the police station, once inside the police station, everything is clouded, right? How that incident is to be appreciated under the Evidence Act. That is what,
May I refer section 6 of the Evidence Act?
okay, let us see the FIR. How far is the police station?
7 kilometers.
7 kilometers. Okay.
Subsequent.
Conduct. You may have to make submission on that.
Motive preparation and previous subsequent.
Ah. This act of going towards the police station with dao in hand, whether it is a conduct, subsequent conduct, it is a conduct.
Yes, subsequent conduct.
Under 8,
Yes.
section 8.
Yeah.
But how it is to be treated, when it is to be treated as an implementing circumstance.
Any fact is relevant, a source or constitutive motive for preparation or any act in issue or relevant. Fact, the conduct of any party or of any person to any party to any suit or suits.
So it is a relevant fact.
Relevant. That trigger. So 2014-12 SCC 439.
Okay, show us. Himan Kole, 2014.
2014-12 SCC 439. Para 9.
Was the Dow exhibited through PW3?
Clerkship. Material.
No. It was exhibited through PW1, who did not see the occurrence. Mr. Prasad, even if the, say, wife of the accused raised a plea, suppose, some kind of unsoundness of mind or to bring in the case under general exception, 84 IPC, and the testimony of PW5, I heard that so and so, so and so.
Even one.
Now,
Two. That you're suffering from.
now you come to page 38. 38.
30.
Question number 20. PW4, fourth line. 3 days prior to this occurrence, you were ill. At that time, you tried to run here and there, did not want to stay at home. You used to fear when you saw other people. Your answer, I do not know. This is not true.
I do not know.
This is not true. At the same time,
My lordship will
come to page 39.
39.
Question number 23. PW5, Kamini Hansepi. On hearing that you were ill, she went to your house. to inquire about your health. Huh? Right. You say this is not true. Huh?
Madam.
And that is the time when you should have raised the plea to bring.
Insanity.
Hmm.
Now, the first opportunity that I got to raise this issue was when my confessional statement was recorded immediately on the next day. The day I was arrested, produced before the court.
That already has been discarded.
Discarded. No, not discarded. The trial judge has accepted that confessional statement.
Trial judge has accepted.
Madam, at paragraph 48, madam, page 86. '86. Paragraph 48. Fourth line, and hence the confessional statement of the accused is found to be voluntary. It is further pointed out as so and so. Thus, the authenticity of the commission of the gruesome murder was so and so.
No, you read
Is-
the total paragraph. First
Is-
line, in reply.
In reply,
Ah,
in the earlier part,
Re-
in
read,
reply,
read.
the PP has vehemently objected to the point raised by the learned defense counsel. He has pointed out that the confessional statement of the accused person has been recorded by PW 10 by observing all legal formalities, and hence the confessional statement of the accused
It
person.
is a submission.
Last line of this same paragraph. It is further pointed out by the learned PP so and so that the confessional statement of the accused is corroborated by the victim PW 5 and the other witnesses of the case. Thus, the authenticity of the commission of the gruesome murder by the accused person is proved beyond reasonable doubt.
The whole para is devoted to the submission of learned PP.
Madam, I'm sorry, madam. It's at paragraph 50. It has been, cannot be relied upon.
Hmm.
It has been rejected.
The whole paragraph 48 is devoted for a submission of
Paragraph-
PP. Because the preceding paragraph was
Of the defense.
learned counsel for
For the
defense, right? So he recorded the submissions. Thereafter, he
In paragraph
recorded his findings.
In paragraph 50, last.
Ah. 50, he started discussion in 50. Then before that, I think Sarwan Singh, Ratan Singh,
49, 50, he has discussed.
50.
It has been
That
rejected.
cannot be taken into account and relied upon.
I have
Page 89 or so.
Ah,
89.
paragraph 50, last line.
Last time.
No.
The condition of the accused person cannot be,
It is
that
not-
is gone.
It is not. Otherwise, he has stated.
We cannot go into the
Go into that.
under police influence. That is gone.
That's
Second is by, say, eliciting some part
from the.
through PW4 and PW5. But you have discarded everything. 313.
339.
This is not true. Meaning that you are fit and fine. That is also gone.
And
That has also balanced the situation.
And more so,
We are back to square one.
more so I called defense witness.
You defense witness,
He also gave against me.
he was against you. So your plea of insanity is
No.
not on firm footing. And that is also C 105. Evidence Act. Hmm. When a person is accused of any offense, the burden of proving the existence of circumstances, I plead on you, bringing the case within any of the general exceptions. I think section 84 is a general exception.
No.
In the Indian Penal Code, leave aside that, or within any special exception, don't require, or proviso contained in any other part of the same code, not required, or in any law defining the offense,
The
is
first,
upon him.
the first illustration. Now.
And the court shall presume, court will presume,
The absence of such.
court will presume that you are not insane. Once discharged under section 101, the life burden is discharged by the prosecution under 101. 84 exception to prove the case and to bring the case within the general exception covered by section 84. one, you have to, burden is upon you. And at the same time, court will presume absence, meaning thereby you have to disprove.
Disprove.
Illustration A. You said that C13. This is not true.
This example, section 313 is behave like.
That is what I have pointed out. So far as unborn child is concerned, I think there is no medical evidence. Anything?
Statistic. 50 versus T2.
Postmortem sound. Where is the postmortem? Fracture of photoconus.
Exhibit
Fracture of occipital bone extending from mid of occipital bone. Which is the occipital bone? Photoconus. Occipital. Wait. Occipital, mid of occipital bone to the right side of occipital bone. Just above the right side of cervical vertebra. This part. Cervical vertebra.
It is at the backside. Below.
A fracture of frontal bone extending from mid of anterior frontal bone. Wait. Frontal bone. Frontal bone, mid of anterior frontal bone to the mid of frontal bone posterior. Yes, somebody said this. So, brain matter, blood vessel of occipital region, frontal region are ruptured. Child of 3 years of age. So it clearly comes under thirdly. Motive is not proved.
Motive. Motive intention.
Direct evidence. You were silent in 313 regarding your unsoundness.
Second.
And why did you bring DW1? Let us see DW1.
Page 28.
28. Right. So Mala and this thing, Kamini were sisters.
Sisters.
There is some discrepancy regarding authorship and
Yes.
Hand cut.
Perhaps Lordship, initially, the injured persons and the deceased were taken to the police station by handcuff. Thereafter, as per the deposition of DW1 and the IO, those three persons were sent to before police station, before hospital, through auto rickshaw also. Might be there is some discrepancies in that.
he also suffering from, he also saying suffering from illness.
Illness, no? Insanity.
At the time of so and so, my situation nearby. During the time of when there was 7, they were on Sondot happened. I came to my school, informed me about the event. When boy, this part I am not, page 29,
Madam.
second para, on the day of the occurrence, one Sondoterang, that is PW3,
Yes.
and one another person
From the village.
from the village came to my school and informed me about the occurrence. Thereafter, I came to my house and saw that my son and my wife were on bed inside the house. This is,
Their
Because,
houses were adjacent.
no, good understand. Let us see.
Madam.
I saw that my son Levision was expired. My wife was struggling with her life. Thereafter, I took my wife to Bukajan Civil Hospital with the same authorization from which I came from the school to my house.
Yes.
Right.
Initially,
Then, as per advice of Doctor of Bukajan Hospital, I again brought my wife to Dimapur Civil Hospital. This part. Right. Then let us see IO.
PW9,
PW
Nine.
9.
page 20,
Uh,
21.
Page 21. Second paragraph, last part. After that, I prepared one requisition letter for treatment of the two injured ladies, namely Kamini Mala, and sent the same to the medical and health officer Bukajan Civil Hospital with Constable so and so. Now come to PW1. I think he did not visit the PO. Right. He said, see, on receipt of 1, 2, 3, 4, 5, 6, 7, 8, 8 line. On receipt of the information, I went to the Bukajan police station and informed the police about the matter. In the meantime, the accused Borsing Phangso had surrendered before the police at Bukajan police station along with a dog.
Yes.
Before I reached the police station, the police kept Borsing in the lockup. Bini Terang and some other villagers had taken Mala Kamini Lipson to hospital in an auto for treatment. Okay, that auto.
There. But that's
That auto.
Yes.
taken by DW.
Now in the inquest report. it was-
1 minute. Lipson was declared dead in the hospital, and dead body was brought to Bukajan police station at around 3 p.m. Okay. People are saying it was 9:30, 10
Like
10.
10:30.
or 10:30. Then PW3 went to DW1. DW1 came with an auto rickshaw to his house. In the meantime, they were
They were
taken
taken to
to
Police station.
No.
Inside the house.
inside the house.
Yes.
Then DW came. Sondro Terang, PW3 was also there. But the PW3 says,
We'll get it page 10. Page 10.
pasting. And then I then took the injured person to the hospital. Page 10, third line from bottom. Right. So not inconsistent.
He is just skipped that he went to the school, brought him back.
No, he skipped.
That part has been skipped.
Skip. And what does the police say?
I would page 4.
Again,
9, page 20.
where he said about Thela, okay, PW 6 says at 1 p.m. 10, let us say about 10.
Around the
Then PW3 went to
school.
school. Husband came in with an auto rickshaw. In the meantime, they were brought inside the house of the DW1.
Yes.
Then from there, they went to Bukajan.
Urgent hospital.
Mala was also taken.
Follow this.
At 1 p.m., doctor examined them.
3 p.m.
Somebody said 3 p.m.
3 p.m. they have went to the
Ayo?
police station.
They came back.
They came back from the hospital.
That is inquest report if you go through.
Inquest.
Yes.
96.
Let us see. Inquest. 96. I started. Informant and the relatives have brought the dead body in an auto rickshaw.
Not
So same auto rickshaw could
same
be.
one.
It was held where? Inquest
At the police station.
The police station.
at the police station. And Ayo,
Page 20.
yes.
21 period.
This part, hand card, this is only.
Here he says hand, but otherwise.
Otherwise, inquest,
Everybody says. it's a-
inquest in his inquest report, I think.
He has
Corona
given
Bora,
the number, registration number also.
Corona Bora. Corona Bora. Only that is a discrepancy.
Fine. Otherwise, he has himself issued those requisition for the two. injured
Where it
persons.
is 3 p.m., 3 p.m. Somewhere it is 3 p.m.
So it is there.
When? Somewhere we have seen
Lordship paid PW1 is stated to 3 p.m.
3 p.m.
Lipson was declared dead in the hospital and the dead body was brought to the Bukajan place around 3
3
p.m.
p.m.
1, 2,
I think
2, 5, 6,
quite nature, nothing to be disbelieved.
12.
Injured witness. Such witness. Who has. Could be taken part in the post of could be treatment being formed. Is a relation. Is a relation. The injured was his sister-in-law. And the disease was his nephew. So disease was nephew of PW3. Injured was his sister-in-law. He is taking active part. Was quite natural. DW has defeated your cause, DW1.
Lordship, there is a difference between interested witness and related witness also.
Right. There is defense has not brought any animosity
Yes.
of the accused or his family with PW3. In fact, PW5 said we had cordial relation. Motive is unknown, but motive in a case of direct evidence is not a factor. Okay.
So that
Ah.
we will also apply to one citation also regarding motive, that is not relevant when there is direct evidence. And regarding chance witness also, will be given one Ramchand Rai and others for state of UP.
This Vivek Kalra, which part?
Vivek Kalra is section 8 of evidence set. There are 9 motions. Motive preparation in previous subsequent.
Para 9.
It is true that PW so and so has stated that they have a good behavior and have prepared for section 8 of the Indian Evidence Act, 1872, however, provides that the conduct of any person offense against whom is the subject of any proceeding is relevant. If such conduct influences or is influenced by any fact in issue or relevant fact, whether it was previous or subsequent to it, hence its behavior or conduct of the appellant would be relevant if it had nexus with the offense under section 302, alleged to have been committed by.
Which decision you want to?
Version on no decision, Ramesh Chandra Rai versus police officers versus state of UP.
Allahabad.
So I
Allahabad High Court.
Supreme Court.
Huh? Allahabad High Court.
This 2014 0 Supreme AW1, 1895 and 2052 ADJ and UC3. Yes, what are the
Bipin Chandra Mohan.
Zero Supreme. 2015 ABJ, wouldn't take against 3. Versus state of Allahabad. Allahabad. There are 29, 21, 32, 33, 34, 38. Very good.
Yes.
Very good.
Okay. This.
Regarding motive, paragraph 39, regarding chance witness motive, paragraph 29, 41, 42, 33, 34.
This criminal case. From jail. And the section 383. Code of Criminal Procedure 1973 CFPC code is presented against the judgment and order dated 13/12/2022 passed by the Court of Learned Sessions Judge Yarbiang Long, and Difu. We didn't make it a trial court for Sol. In sessions, case number 275 stroke 2017, within bracket new. Bracketer ভিতৰত sessions case number 42 stroke 2005 within bracket old. Comma which arose out of ZR case number 444 stroke 2002 and Bukajan police station case number 164 of 2002. Post. By the judgment and order dated 13/12/2022, the learned trial court has convicted the accused appellant for the offense of murder under section 302, Indian Penal Code, and he has been sentenced to undergo life imprisonment and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for another year. First, the accused appellant has also been found guilty for the offense under section 326, IPC. And he has been sentenced to undergo rigorous imprisonment for the period of 10 years and to pay a fine of rupees 10,000, in default of payment of fine, to undergo imprisonment for another year. Also, the sentences are ordered to run concurrently. Also, para. The prosecution story, in brief, is that on 19/12/2002, one Lokeshwar Teron, within bracket PW1, as the secretary of the concerned village defense party, Bhetagaon, Sorihajan, lodged an adjournment at 3 p.m. on 19/12/2022, stating inter alia that at around 10:30 p.m. on 19/2/2022, the accused appellant wounded 19/12/2002. The accused appellant wounded inflicted injuries on the person of one Srimati Kamini Hansipi with a DAO, by hacking her with a DAO. Apart from hacking her child to date, when Kamini Hansepi with her child went to pay a visit to the house of the accused appellant on that day. The FIR further stated that the condition of Kamini in TP was critical. The informant further stated that the accused appellant also wounded his own wife by hacking her with the same DAO. The informant also mentioned that the accused appellant had, in the meantime, surrendered himself in the police station. On receipt of the FIR, command officer in charge registered the same as Bukajan Police Station, case number 164 of 2002, under section 326 and section 302 of the Indian Penal Code, and entrusted the investigation to one Corona Bora, PW 9, N, Assistant Sub Inspector of Police attached to Bukajan Police Station. During the course of investigation, Commander Ayo recorded the statement of the witnesses under section 161 CRPC. As the accused had purportedly surrendered at the police station on 19/12/2002, the IO took him into custody and thereafter arrested him. When he was sent to judicial magistrate?
On the next day.
State submitted.
On 2012/2002, the IO forwarded the accused to the court for production, along with a prayer to record the statement of the accused under section 164 CRPC. Post of the statement of the accused was recorded under section 164 CRPC on 2012/2002 by a magistrate by magistrate by one Jyotirmoy Loimari, within bracket PW 10, magistrate first class posted at the office of the Deputy Commissioner, Kardiangal, before post of the inquest proceeding on the dead body of the deceased named Solemn given, it's solemn given up to solemn মানে বলকে বুলবুল পোস্টমর্টম তো বলেছিলাম ডিভিশন তামাং লিডের উর্দু বা কি তামাং বাপেকে কি বলছে বাপেকে EW1 Levision LEVISON Terang TERANG তাৰপিছত এড দি পেলাই লিভিশন LIVISON তামাং কাৰেক্ট এইটো টাইপ কপিহে এইটো ভুল লিখিব পাৰিব এইটো টাইপ চবে চালেহে বুজিব কি মানে কৈছে তামাং পোস্টমর্টম তামাং নেপালী মানুহ লিভিশন আগে কি কৈছিল এই লিভিশন দেন লিভিশন লিভিশন উল্টা পোলা লিখি থৈ দিয়ে মানে ইমান যে তাৰ ফলত যে সময় নষ্ট হয় এইটো বুজি নাপায় লিভিশন Terang Caribbean has become because of typographical mistake has become Terang from Tamang from Karbi to Nepal. Is it not? Division Tamang. A child of 3 years of age within bracket approx on 18 inquest 1912-2002 at the police station post office. As the a dhow fitted with a bamboo handle was seized from the possession of the accused at the police station on 1912-2002 by the seizure lists in presence of witnesses. The postmortem examination of the dead body of the deceased was performed at the Civil Hospital on 2012-2002. বুঝলাম। একটু তার আগত সময় দিও মাজত। As there were two injured persons, they were provided treatment at Bokajan Primary Health Center, PHC, at around 1 p.m. on the date of the incident itself, that is on 19 to 2002, before referring them for further treatments. After completing investigation into the case, Bukajan registration case number 164/2002, within bracket corresponding DR case number 444/2002, the IO PW9, submitted the charge sheet under section 173 CRBC. All right.
However, the
Charge
second
sheet.
I have filed the charge.
Huh?
The second I have filed the charge sheet. Is PW8.
Of the completion of investigation, huh? After completion of investigation into the case, HR sheet under section 173 to CRPC came to be late on subsequent 107. White search sheet number 70/2002 on 31/12/2002, finding a privacy case against the accused for committing the offenses under section 326 IPC and section 302 IPC. Posted para. On submission of the search sheet, the procedure of furnishing the copies were complied with, and the case was forwarded. PW 1 to examine for 11. 1 to September 2009. The presence of the accused was secured before the court by issuance of process. First of the after hearing the learned public prosecutor and the learned defense counsel, and after open perusal of the materials on record, charges under section 326 IPC and section 302 IPC were framed against the accused on 24/7/2008. Postal. After framing the charges, the charges were read over and explained to the accused. Post upon being read over and explained the charges, the accused pleaded not guilty and claimed to be tried. Post the charges, one of the charges framed against the accused was that at around 10:30 a.m. on 19/12/2002, he voluntarily caused grievous hurt to Srimati Kamini in Hansepi. Kamini. Hansepi. And his wife,
PW 5.
Mala, Srimati Mala NTP, Uchedao. The other charge framed against the accused was to the effect that on the same time, date and place, he intentionally committed the death of a 3-year-old boy named Libishan Terang Uitedao. During the course of the trial, the prosecution examined 10 number of witnesses and exhibited 9 number of documents to bring home the charge, apart from a material exhibit, to bring home the charges against the accused. Full stop. The accused after examination, after closure of the evidence from the prosecution side, the accused was examined under section 313 CRPC, 3131B CRPC. By bringing to his notice the adverse incriminating circumstances appearing against him in the prosecution evidence. Full stop. The plea of the accused was total denial. Full stop. When he was asked to, when the accused was asked as to whether he would adduce any evidence in his support, he stated that he would adduce evidence, defense evidence. Full stop. The accused had thereafter examined one sourcing thereon as did only one. Full stop. The particulars of the prosecution witnesses, defense witness, documentary evidence, and the material object adduced during the course of the trial, whereas under page 93.95 video. Para. After hearing the land counsel for the parties, to state defense legal. And engaged in state defense. And after hearing the land public prosecutor in the land defense counsel, and after appreciation of the evidence through materials on record from the trial court, had passed the judgment and order date of conviction and sentence apostate on 13/12/2022. Postal agreed by and dissatisfied with the impugned judgment in order of conviction and sentence, the present appeal has been preferred. Postal we have heard Mr. B. Prasad learned amicus brief for the accused appellant and Ms. S.H. Bora learned additional public prosecutor for the respondent state. Postal. Okay, we'll come back. Mr. Prasad and Ms. Bora, we'll continue up to 1 o'clock. If not finished, then we'll put it on another day. Tomorrow is not possible. Perhaps tomorrow there will be farewell reference, might be at 2 o'clock. There is another division, so either on Thursday or Friday, we'll not keep it CB. Yes, what is your submission, Mr. Prasad? One is charge witness. The next one is wife.
Wife.
Did not
CL
support
did not
fully,
support
did not support
evidence.
fully.
Even
Then
PW5, she also did not support the injury to her. She has supported the injury to her, but not to the child.
PW5.
PW5, ma'am.
Oh, is it so? Is it so?
Page 14, ma'am. Regarding the child, she says, I learned later on. From below, third line.
Okay. She learned.
She learned.
But that she went with the child that she
That is
said,
right. That is
she
right.
lost consciousness.
She lost.
Okay, then
Then insanity, but no specific.
these are the four and 164 statement. Mr. Prasad, Senator Mike is appearing for the appellate has submitted that the appellant had raised the issue of his mental his unsoundness at the time of commission of the offense at the very first occasion on 20/12/2002 when his statement under section 164 CRPC was recorded. Custom. The fact that the appellant was mentally disturbed was also supported by PW 4 in her testimony. Custom. That the appellant was a mentally disturbed person was also corroborated by the by PW 5 Custom. It is his submission that the testimony of PW3 is to be examined meticulously as he appears to be a chance witness. And upon meticulous examination, it would emerge that his testimony is not to be believed. Custom. The prosecution story was to the effect that both PW4 and her child, that is the deceased, went to the house of the appellant at the relevant time. Custom. And at the relevant time and the appellant assaulted them with a dao. which resulted into injuries on the person of PW4 and the death of her child. But PW4 did not depose anything regarding witnessing of assault on her child. On the other hand, it was only PW3 who PW3, a charge witness, who stated to have witnessed the assault on the child. The testimony of PW4 did not wholly support the prosecution case. The other witnesses, PW1, PW2, and PW2, were not eyewitnesses, and their testimony were hearsay in nature. The fact that the appellant was suffering from illness was also endorsed by the defense witness, DW1. It is a submission that if the entire evidence on record is taken into consideration, it would emerge that the prosecution has not been able to prove either the charge of murder or of causing grievous hurt beyond all reasonable doubt. In the case of the appellant regarding his unsoundness of mind is to be accepted as the standard is preponderance of probability. He has thus submitted that as the case of the appellant is one under general exception covered by Section 84 IPC. The judgment and order of conviction and sentence is not sustainable in law, and therefore the accused appellant is entitled, is liable to be acquitted. Para vehemently opposing the contentions of the land amicus brief for the appellant, Ms. Boral, and a petition public prosecutor appearing for the state has submitted that notwithstanding the facilitating testimony of the wife of the appellant, PW4, there is an injured witness in the form of PW4, 5, whose testimony is has fully supported the case of the prosecution. Post of the testimony of PW3, sorry, the prosecution witness, PW3, fully supports the prosecution case, has fully supported the prosecution case. Post of the PW3 being being a eyewitness to the assault on the disease side, and there was failure on the part of the defense to establish unsound use of mind on the part of the appellant at the time of commission of the offense, the contentions advanced by the appellant on behalf of the appellant do not are not sustainable in law. Full stop. It is true. MS Bora has further submitted that it is true that the confessional statement of the appellant recorded under section 164 CRPC has been discarded by the trial court due to non-compliance of the necessary safeguards. Full stop. Even if the confessional statement of the appellant was not taken into account, the prosecution has been able to bring evidence on record establishing the case beyond all reasonable doubt. Also, apart from though a feeble plea of unsoundness has been raised by the appellant, the same cannot be said to have met the standard required by section 105 of the Evidence Act. Post stop. The nature of injuries sustained by the deceased go to establish that the disease was assaulted with the intention to cause death and the appellant has rightly been convicted under section 302 IPC. Postal. Summing up, the additional public prosecutor has submitted that there is no ground to interfere with the judgment and order of conviction and sentence passed against the appellant. Postal. Where we have given due consideration to the submissions of the learned counsel for the parties. And I have also gone through the evidence of materials on record available in the case records of Sessions case number Sessions case number 275 stroke 2017 within bracket new. Goes to para. It was on the basis of the FIR within bracket EXT1, the contents of which I mean briefly recorded here in above, the investigation of the case was initiated. Question. Para. From the evidence stroke materials on record, it has emerged that the prosecution witnesses, PW4, Mala NTP, and PW5, Kamini Hansepi are sisters. Sisters in relation. Full stop. The appellant is the husband of PW4, Mala NTP. And therefore, the appellant is a brother-in-law of PW5, Kamini NTP, Hansepi. DW1, Sarsing Terang, is the husband of PW5, Kamini Hansepi. The deceased, Libison, Libison, Terang, was a child of PW5, Kamini Hansepi, and DW1, Sarsing Terang. It has further emerged from the evidence on record that the houses of PW4, Mala NTP, and the appellant on one hand, and the house and of PW5 Kamini Hansepi and JW1 Sarsin Terang were located adjacent to each other. Question. PW1, the informant, was the secretary of the village defense party of Hetagaon, Soriajan, at the relevant point of time. Whereas PW2 was an inhabitant of village of Hetagaon. Full stop. PW six was serving as the medical and health officer -1 at Bokajan PHC on 19/12/2002 when he examined both PW4 Mala NTP and PW5 Kamini Hansepi. At around 1 p.m. Posto. PW7, Dr. Ruplal Munisa was serving as Senior Medical and Health Officer at Difu Civil Hospital on 20/12/2002 when he performed post-mortem examination on the dead body of the deceased child, Libishan Tehran, in reference to Bokajan Police Station case number 164/2002. Full stop. PW9, Corona Bora was the investigating who initiated a substantial who conducted and who completed a substantial part of the investigation after being entrusted to investigate on 19/12/2002. Was the PW8 was the officer in charge, Bokajan Police Station, during the period from 28/12/2002 to 31/12/2002. And it was on 31/12/2002, PW8 submitted the charge sheet within bracket EXT 6 postal para. As it is the testimony of PW3, Sondra Terang, which has been extensively referred to by the learned counsel for the parties, we turn to his testimony at first. Full stop. In his evidence in chief, PW3 stated that he knew the informant, Lokesh or Teron, PW1, the appellant, the deceased, Libishon, Tehran, and the injured person, community no? Injured person, was Kamini Hansepi, within bracket PW5, postal. He deposed to the effect that on the date of the incident, he went to Hanse Bosti, and when he was passing by the front of the appellant's house, he saw the appellant hacking the son of Kamini Hansipi, PW5, with a dao in his courtyard. PW3 stated that the appellant also chased to hack another boy of Kamini Hansepi. At that time, as Kamini Hansepi came in the way, the appellant hacked her. PW3 stated to have taken the other son of Kamini Hansepi to her house to keep him there. The son of Kamini Hansepi, who was hacked, died in the courtyard of the appellant. PW3 further stated that Kamini Hansepi are on being hacked, fell unconscious on the ground. He then took Kamini Hansepi to the hospital. PW3 further saw the accused appellant going towards the police station with the dao in hand. PW3 testified that the incident took place at around 10:30 a.m. He further stated that the house of Kamini Hansepi and the appellant were adjacent to each other. Kamini Hansepi was treated in a hospital at Dimapur for about 20 days. On being informed, the police personnel arrived at the place of occurrence to take the dead body of Kamini Hansepi's son to the police station. The dead body was thereafter taken to Difu Civil Hospital for post-mortem examination. And he accompanied the dead body to the hospital. PW3 further stated that he was present when police held the inquest on the dead body of the deceased. And he gave his signature as a witness to the inquest report, EXT 2. and identifies his signature therein as ext to 2 parts. Full stop. When subpara, when PW3 was cross-examined, he stated that the Kamini Hansepi's husband, Sar Singh Terang, was his elder brother in relation. First of all, he stated that on the date of the incident, he went to pay a visit to Sar Singh Terang's house. First of all, when he arrived at the place of occurrence, the appellant, his wife, Mala NTP, PW 4, and Kamini Hansepi, PW 5, were present there. He did not know if there was any dispute between the two families. Houston. PW further stated that when the appellant had the deceased and assaulted Kamini so-and-so and her deceased son, the father of Sar Singh Terang and the father-in-law of Kamini NTP was present in his house consuming liquor. Pota Terang, POTA Terang. Pedro's chief further stated that he did not know why the appellant had assaulted the deceased and the injured. He categorically denied a suggestion put to him by the defense that he did not witness the incident. Para. PW5, Kamini Hansepi, in her examination in chief, stated that on the date of the incident, 19/12/2002, she, along with her deceased child, had gone to the appellant's house to inquire about his health as she heard about his illness. PW5 further stated that at that time, she was 9 months pregnant. Going to the house of the appellant, she inquired about the appellant's health. And it was at that moment, the appellant inflicted injuries on various parts of her person. So as a result of the assault, she became unconscious. It was later on, she came to know that she was taken to the hospital at Dimapur for treatment. And the appellant had hacked her son had also hacked her son, who died instantaneously as a result. Full stop. PW 355 further stated that she was informed by the doctor that her unborn child also passed away at that time when she was under treatment in the hospital for about 3 months. Full stop. During cross-examination, PW5 stated that she did not know whether the appellant was made at the time of the incident or not. She did not know about the mental condition of the appellant at the time of the incident. So she further stated that they had her family. Oh, sorry, she and her family had no dispute with the appellant, and there was cordial relationship between them. So stop. As there was cordial, as there was only cordial relationship, she went to inquire about his health. First of all, she stated to have heard that the appellant had become insane. Insane. Full stop. She stated that she did not know if the appellant had committed the incident, having gone insane. Full stop. Period 5 further stated that the appellant had not hacked us, had not assaulted her and her son intentionally. Full stop. PW4, Mala intervened in her examination in chief, admitted that deposed that the incident took place on 19/12/2002 at around 10 a.m. on 19/12/2002. PW4 stated that the appellant was ill for 3 days before the incident, and he was exhibiting restlessness. According to PW4, the appellant shown inclination of not not to stay in house in home, and he used to get scared on seeing any third person. PW4 stated that at around 10 a.m. on the date of the incident, she went to fetch water from a pond. And at that time, the appellant was inside their house. When she came back with water, she told the appellant that she was going to boil water for him. When she returned with water, when she returned with boiled water, the villagers told him that the appellant had hacked her sister-in-law, comma, Kamini Hansepi, his son. On having heard so, comma, she threw the pot on, she returned home and saw that Kamini Hansepi's son was lying in their courtyard after being hacked with a dao. She saw wounds on the back of the child. PW4 stated that on being frightened, comma, she fled from her house, and it was only on the following day, comma, she returned to her house. So it was Sarsing Terang within bracket DW1 who informed her that the appellant had also hacked Kamini Hansepi with a dao. Kamini Hansepi PW5. So PW4 stated to have noticed cut marks on the face of Kamini Hansepi PW5. PW4 further stated that when she returned home, comma, she learned that the appellant was arrested by police. During cross-examination, comma, PW5 stated that she got the news when she was going, while she was going to fetch water. When she returned home, comma, she did not find anyone in her house. PW4 further stated that she did not see Sondro Terang within bracket PW3 in her house. Sondro Terang, PW3, comma, who was a member of Kamini Hansipi's family, comma, in her house. PW4 further stated that the appellant was ill at the time of occurrence and he behaved like a lunatic. The appellant used to make attempts to escape from the house, and his such behavior was for about 3 days prior to the incident. Paragraph. Before appreciation of the evidence of the aforementioned three witnesses, comma, we turn to the testimony of the medical officers who treated, who stated to have treated the injured persons, comma, Kamini Hansipi PW5 and Mala NTP PW4, and performed the autopsy on the dead body of the deceased child, comma, Libishon Terang. Full stop. Para. PW6 in his testimony, state deposed to the effect that at 1 p.m. on 19/12/2002, he examined both Kamini Hansepi PW5 and Mala Intibi PW4. Full stop. On examining Kamini Hansepi, he found a deep cut, page 16, a deep cut injury over right side of her neck, involving muscle and deep structures. Full stop. At the time of examination, PW5 was in a pool of blood. Full stop. PW6 testified that the injury was caused by a sharp cutting object, and the nature of injury sustained by PW5 was grievous in nature. Full stop. When he further deposed, PW6 further deposed that when he examined Mala NTP PW4, he noticed a deep cut injury over frontal scalp involving muscle and blood vessels. Full stop. He opined that the injury was caused by a sharp cutting object. Full stop. However, the nature of injury sustained by Mala NTP PW4 was simple in nature. Full stop. PW6 exhibited the medical report which he prepared after medically examining PW4, Mala NTP, and so PW5 as EXT 4. Postcode. From. All right. During cross-examination, PW6 stated that the kind of injuries sustained by the two injured persons could be sustained during a minor fight. And he did not mention in Exhibit 6 about the depth of injuries sustained by the two injured persons. It would be legal after. If immediate treatment was given to the injured, he would not have died. Perhaps, okay, we'll record. The boy was also taken, perhaps. But PP should have been more alert that the boy was also taken and he should have. PW6 further stated that if immediate treatment was given to the injured, he would not have died. From the testimony of PW6, it has emerged that on 19/12/2002, the injured persons, Mala NTP PW4, Kamini Hansepi PW5, along with the body of the minor child, dead body of the minor child, were taken to Bukajan PHC for examination. person. The injuries recorded in respect of the two injured person, Malay NTP, PW4 and Kamini Ansebi PW5. In the medical examination report exhibit, within bracket exhibit 4, are found consistent with the testimony of PW6. Most of the defense has not been able to elicit anything as regards and again, in this week, we'll be dining at this 3 o'clock because of some other. We'll put it on Thursday. If not possible, then we'll put it on seal. We'll put it on Thursday, we'll complete the conference. Right. Good. It will need to, be proceeded, as it was yes, the, yes, again on so and so, again on Thursday. At 10:30. 10:30. 10:30 will be closed. There will be many changes in between.
May I please also? With regard to item number 3, madam. Item number 3, madam. I'm seeking some accommodation
Okay.
for 2 weeks.
Or
2 weeks.
Mr. B. Prasad, learned counsel for the appellate, has made a prayer for adjournment for the appeal. So Ms. L. Devi, learned counsel, appearing for the respondent, and I have submitted that there is no objection to the prayer for adjournment. So in view of the prayer for adjournment, with consent, release the case after 2 weeks on a date to be fixed by the office.
4 and 5, madam.
Item number?
4 and 5, madam.
Yes.
Can it be after 2 weeks, madam?
Okay.
Any day.
The prayer of Mr. D. Boran. Council. Appearing for the appellates. Release the case after 2 weeks on a date to be fixed by the office as Ms. B. Bhuiyan learned. Additional public prosecutor, senior counsel and additional public prosecutor for the respondent state. Has submitted that the state has no objection to the state prayer for adjournment.
Another item, madam, regarding item number 1, madam. I'm preparing for item number 1, madam. 1 and 2 is both the take matter, madam. Can this matter be adjourned for the day, my lord?
Court will give you on the, for the day.
Sorry, my lord. Not this matter, my lord.
One,
No,
Two.
4 and 5, my lord.
four.
Sorry. Sorry.
Middle is for hearing. Items 1 and 2.
How many witnesses?
There are 22 PWs and 3 DWs.
1 hour not
It's not
sufficient.
possible. No. Not possible.
So this bench is for only 1 week. Thursday, we have part-heard matters also. At 1 plus 2, 3 NDPS. And every day it will be rising early. There will be references.
Yes, yes, ma'am. This week, ma'am. This week.
Thursday, Friday, there will be references. Perhaps. I've been told. No second half. Yes, Miss Bhuya, are you ready? Maybe in the next week,
Well,
because we'll fall short of time perhaps this week.
it's rather long, ma'am, the PW.
302,
302 and 392, ma'am.
3
392 probably.
robbery.
Oh, no.
How many accused?
There are,
Convicted?
item number 1 accused, my lord, and connected matter, my lord. Item number 2, my lord, is another, ma'am.
Arising out of same judgment.
ma'am. 2 accused persons, my lord.
Maybe in the next week, since they are in custody jail for 8 years,
My lord.
so we'll put it in the next week.
Well,
Okay. Mr. N. Mahajan and counsel for the appellants and Ms. B. Bhuyan and senior counsel in addition for the prosecutor state or present poster and sought for by the learned counsel for the parties. Release the appeals on a date in the next week.
obliged, ma'am. Highly obliged.
Item number 6.
Unfortunately, your paperwork is not provided to us by our office.
Is it? Miss B. Chaudhary, learned Amicus Curiae for the appellant is in attendance. Miss B. Bhuyan, learned additional senior counsel in addition, public prosecutor for the respondent state of Assam. Response state has submitted that the paper book. You're not collected or collected.
Provided to all office concerned.
Let me see otherwise. Offense 302. Check. Collected. The paper book is yet to be collected from the registry. Posto. Ms. Bhuyan has thus paid for listing of the case. How many years in jail? He is written. After a week. As in the meantime, command of paper would be collected from the registry. There is nothing that state has collected. It has collected. So each of them.
I'm getting jealous.
There is nothing that state has collected. Collect. Which Choduri has collected, but state is not there. You collect it. Or you have misplaced.
I cannot say what the officers are.
Oh, it is there. Okay, okay, it
I'll
is
give
there.
you
Oh,
both.
okay, okay, okay. Submitted that, the paperwork collected, comma, has been misplaced in the office of the public prosecutor. So, MSP has thus paid for listing of the case after a week. In order to trace out the paper. So misplaced also. The having regard to the ground cited, comma, the appeal stands adjourned for a week. To list the case on a date. Office list the appeal on a date after a week.
7. Item 7.
Raja Robidas.
So
Also, legal aid counsel,
I'm told, I know when this Borman's father is not there, so she might have left early. Is it great?
the learned amicus curiae for the appellant is found absent today on call. Goes to Miss B. Learned senior counsel and addition for the prosecutor for the respond number 1, comma, state of Assam is present. Goes to MSP has further informed that the learned legal aid counsel for the respond number 2 has some medical issue at home. Goes to in view of the book, comma, let the case be, and let the appeal be listed. Till we can need to fix back hours. Week.
3.
She. Yes,
Please, your lordship, lordship. Senior counsel is on his way, lordship.
on his way.
Yes, lordship.
Is Mayor ready?
I'll go to 11. Starts.
Jail appeal.
Two.
Father.
13 numbers.
Question is how much material?
Lordship, at the last order, the complainant is supposed to serve a notice, whether there has been served or not, or either by a maker security to represent the complaint.
Comment was directed to be impleted. Office note. Okay,
Others, I am ready
okay.
from my part is ready.
Service report has not yet been
My-
received.
my- Because that order is there until unless my notice is served to the,
Okay, since someone, coordinate bench has ordered already, so. Offense is under what?
my lord, 447 and 302.
Otherwise, it was not required, but still there is an order.
Court's order, my
Coordinate bench, we have to respect it. Heard Mr. M. Holonial and amicus curiae for the appellant and Miss B. Punya. Then a senior counsel in addition, public prosecutor assisted by Miss M. Das. Ardas or Ardas? Learned counsel for the respect number 1 on state of Assam. So, it was ordered on 19/1/2021 to implement the informant as the respond number 2 and to serve a notice upon the informant as respond number 2. Also, as per office note dated 27/6/2025, comma. No service report. As regards service or notice upon the informant as respondent number 2 has been received by the section till date. From the officer in charge, Mornoi Police Station, District Kualpara. Full stop. Office 2. Issue a reminder. The officer in charge, Mornoi Police Station. Or a report as regards service or notice upon the respondent number, informant respondent number 2. Full stop. As the appellant has been convicted for an offense under section, for the offense under section 302 IPC, comma, and is in incarceration for more than 7 years, comma, lays the appeal after 3 weeks.
My lord,
Also, it is observed that in the event of non-appearance of the informant as respondent number 2 on the next date of listing, command the appeal will be taken up for consideration.
my lord. My lord.
Last,
Raised it to issue a matter.
The informant is the son of the deceased, my lord.
okay. Since order has been passed, otherwise.
My lord, otherwise not required.
Not required, but since order has been passed, we have to respect it.
My lord.
Only. We did not last 1 hour.
Items 9 and 10.
Yeah. The land council for the appellants found absent to the
For item 10.
10. Okay. Not in 9. Land council for the appellant in 9 is found absent to the to stop. The land council for the appellants in 10 is present. And the land council for the state are present. In view of absence of the land council for the appellant in 9, the land council for the other parties have submitted that the appeals be listed after 2 weeks. So the prior allowed, please back his appeals after 2 weeks on getting this videos.